We're going to get started. Welcome to today's forum on gerrymandering and the Constitution in Diedrich College at Carnegie Mellon University. I'm Stephen Schlossman, Professor of History and Director of Undergraduate Studies in History here at Carnegie Mellon. The History Department at Carnegie Mellon has a long tradition of integrating historical and contemporary inquiry. That is one reason I was recruited from my research posts at the RAND Corporation and the California State Assembly 30 years ago to teach in our then thriving applied history program, pioneered by Professors Joel Tarr and Peter Stearns in the 1970s and 1980s. From the time I arrived, our department has never hesitated to reinvent what we teach and how we teach history in order to address public policy issues in the contemporary moment. And that is exactly the logic behind the History Department's sponsorship in coordination with the CMU pre-law program of today's forum on gerrymandering and the Constitution. We would like to thank CMU Vice Provost for Education, Amy Burkett, and Professor Corinne Mojasek of the Vice Provost's Office and the English Department for their enthusiastic support of today's event. Without further ado, let me introduce today's forum participants and then step out of the way so that we can launch what I'm certain will be a very stimulating discussion, especially on the eve of midterm elections. First, I'd like to introduce the moderator of our forum, Mary Jo Miller, who is staff attorney for the Pennsylvania State Education Association and a long-term, much-valued adjunct instructor at Carnegie Mellon, teaching courses on the First Amendment and the Bill of Rights. She earned her undergraduate degree in French at the University of Pittsburgh and both a master's degree in international business and her JD degree from Duquesne University. Second, let me introduce the Honorable Maureen E. Lally-Green, Dean of the Duquesne University Law School. Dean Lally-Green received both her Bachelor of Science degree in Education and her JD degree from Duquesne. After a varied legal practice, she served 15 years as a full professor of law at Duquesne Law School before being appointed and then elected as judge of the Superior Court of Pennsylvania between 1998 and 2009. Among many distinguished service appointments on behalf of the judiciary and the Commonwealth of Pennsylvania, she served as chair, vice chair, and member of the Pennsylvania Supreme Court's Appellate Court Procedural Rules Committee, and as chair of the Supreme Court's Gender Fairness Implementation Committee. In addition to her administrative responsibilities at Duquesne Law School, Dean Lally-Green teaches the appellate practice class and most recently a course on governance, compliance, and risk management. Finally, our third forum participant is the Honorable Max Baer, who has served as Justice of the Pennsylvania Supreme Court since his election to that distinguished post in 2004. Before that, he served in several leadership posts on the Court of Common Pleas of Allegheny County, during which time he earned a much-deserved national reputation as a champion of children and families, and almost single-handedly, especially in the area of adoptions, reshaped the operations of the Juvenile Court and Domestic Relations Court. His creative work in these overlapping areas earned him a special meeting at the White House with President and Mrs. Clinton for receipt of an Excellence Award for Judicial Innovation, and many other local, state, and national awards as a tireless child advocate. I'm happy to say that I was clever enough when I was chair of the History Department many years ago to persuade Justice Baer to teach a very successful course for us on constitutional law here at Carnegie Mellon, and that we spent many years together celebrating New Year's Eve, attending pit football and basketball games, and competing with and against each other on the indoor tennis courts very late in the evening in Mount Lebanon. With no further ado, let me turn things over to our moderator, Mary Jo Miller. Let me ask you, if you would, to withhold your questions until after the formal forum discussion concludes and Mary Jo invites questions from the audience. I'm going to bring this mic up to the stand right there, and I'd like to ask those who would like to ask questions to line up, if you would, over there. We'll watch the clock as best we can and do our best to leave enough time for lots of questions. Mary Jo?
Thank you, Steve, and welcome everyone. If timing is everything, we are in an extraordinary position this afternoon to discuss a landmark case in Pennsylvania that, as many cases do, can have consequences in our election tomorrow. Our guests are uniquely suited to discuss the foundations of that case, as well as the case itself, which was based on our Pennsylvania Constitution. And to start, and my goal here is to allow Dean Lally-Green and Justice Baer, as they have in the past, to discuss this openly in a way that I think you will find really engaging and informative. So if we may, Dean Lally-Green, if I can start with you, can you talk a little about how we vote, who gets to decide where we vote, for whom we vote, and what are the constitutional underpinnings of that?
Well, thank you so much. And good evening, and thank you all for being here tonight. I will let Justice Baer share with you a bit about how the two of us came together to do this, but I will also share with you one little factoid, and that is we have known each other since 1971, and we've been classmates with each other, we've served in the judiciary with each other, and we have been friends since 1971. So believe me, there's a long and very deep and respectful friendship that we both share. He'll get into some more of those details later, but it is my great privilege to be beside him here today, sharing with you, talking with you, and answering your questions. So let's get a context. The U.S. Constitution. That's the first place that we look at in order to understand the issues that we're going to be talking about today. One might think that there's just one little clause that defines what we're talking about in terms of voting and who does what and how. But there are really three clauses of the Constitution. The first is Article 1, Section 2, Clause 3. And it says this: each state will have one representative for every 30,000 people. Well, this is obviously not true today, but this was the U.S. Constitution, one representative. Now, you think 30,000, imagine how many representatives we would have. But by statute, the number of congressional seats has been set at, you guessed it, 435 seats. So now that proportion is 1 to about 711,000 people.
And I'm going to interrupt Maureen on occasion. As good friends, we're telepathic.
We're used to that.
Yeah. We get things done. You notice there that she said by statute. The Constitution does not set the number of members of the House of Representatives. That was set in 1913. The population is 2.5 times what it was then. There are proposals to change the number of members of the House of Representatives to 600, and there's actually a proposal out there to change it to 5,000 or 6,000, which obviously would have interesting logistical problems. They wouldn't be meeting in the Capitol, they'd be meeting in your football stadium, I suspect. But it's by statute, and Congress can change it as they like. And the reason is that they're supposed to be representative of the people. And if you have one for every 30,000 as original intent, then query whether one for 711,000 is inconsistent with original intent.
So that's the first clause. The second clause is Article 1, Section 4. Now, you might have heard of this one a little more frequently. And it governs both the conduct of elections and the power to regulate elections. So the conduct of elections in the Constitution of federal senators and representatives is the responsibility of the states, and secondarily with Congress. So right away, Article 1, Section 4 places the state as the primary responsible party for the conduct of elections. Also, the power to regulate elections, time, place, and manner of holding elections is given to the states. That's why you see so many different election times across the United States and ways of electing, whether you elect by ballot that you mail in, you electronically vote, or you go to the polls and stand in line.
And for those of you from Pennsylvania, since September, 37 states in the District of Columbia have been casting votes before Election Day. In Pennsylvania, to try to vote tomorrow, you have to pledge your firstborn or give blood, because Pennsylvania suppresses votes, and it suppresses. And we don't have to get into why, but its current philosophy is to try to not have all of the immigrant and all of the minority vote in Philadelphia turn out in vast numbers, because it can impact the election. So it's hard to vote in Pennsylvania. And people are very concerned that voters will be turned away tomorrow. And there is a remedy. If you're turned away, there's a judge on duty in the city-county building, and she or he will give you a little slip of paper that lets you vote.
Mm-hmm. It's called a provisional vote, isn't it?
It is.
Yes. So that's the second article, Article 1, Section 4. And the third is Article 4, Section 4. And that is basically, I think, to me, a very powerful article. And it, first of all, establishes that the government we have is government by the people, representative government. And that means that a majority of the voting citizens make the political decisions. Citizens are acting directly through their representatives. And then there is...
One of the reasons we're here is that gerrymandering, extreme political gerrymandering, is an effort to thwart that, to put the proverbial rabbit in the hat before you start the trick. And so, to the extent you believe in free, fair elections, to the extent you believe in democracy, you would argue that gerrymandering is a threat to that.
So we have government of the people, and then the second theme in Article 4, Section 4 is there is no monarchy. That if this is not working, it is a political determination to be made by the people. That there's only really one strong Supreme Court case on that, but that is basically try to keep it out of the judicial branch, keep it into the political realm. And we will talk a little bit about what that means. And then the third is that the rule of law prevails. There is no ex post facto law. So those are the three articles of the Constitution that build out the background of the cases that then came later. I'll just, let me sum up so that we have our background. Article 1, Section 2, Clause 3, the proportionality, that the population, the representative, has to be basically representing the same number of people. Number 2, Article 1, Section 4, conduct of elections and the power to regulate the elections are with the state. And Article 4, Section 4, government of the people, there is no monarchy, and the rule of law prevails.
And I was just going to you, we were asked to try to remain clear. Ex post facto, all that means is that the law has to be in place prior to the act. So if you drove down here today on the Pennsylvania Turnpike and you were doing 70 miles an hour, and tomorrow the state legislature changes the speed limit to 60 miles an hour, they can't come to you and give you a ticket, arrest you for speeding, because it was lawful when you did it. That can happen when it turns out that the legislature has never figured out to pass a criminal statute for something that they find abhorrent, animal cruelty, for instance, and then there's an egregious act and they pass it. It does no good for prior acts. It only does good. It can only be used if you commit that kind of act subsequently. It's generally a criminal concept.
Right.
Can you tell us a little about how, when we talk about apportionment, who gets to do that?
Do you want to take that one?
Take that, sure, I'd be glad to. Maureen already explained to you Article 1, Section 2, I believe.
Right.
The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each shall be qualified. And then the time, place, and manner. This is section 4, which I commented on also. And time, place, and manner is a key. As you listen to the talking heads, you'll hear about the time, place, and manner. That's where it comes from. Federal Constitution, Article 1, Section 4. Holding elections shall be prescribed by each state by the legislature thereof. Now that's the key to what Mary Jo asked, because how does the court do it? And I've been asked that question sort of repeatedly. The federal Constitution gives it to the legislature, and the legislature has to do that. And the legislature indeed did that after the 2010 census. That was the 2011 redistricting that my court, with me in the majority, found unconstitutional. So, and so it's up to the legislature. However, it's a court, the United States Supreme Court, state Supreme Courts, inherent, not only right, but really duty, really obligation, to redress unconstitutional acts, because there is nobody else that will do that. And so, to the extent that the legislature does something unconstitutional, be it pass a statute, apportion the state for the House of Representatives, then it becomes our obligation to overturn that. And again, if you think about it, those of you who are from around here, the federal courts in Allegheny County have created Woodland Hills School District to redress discrimination in the school systems. They created the new jail that's down just out of town because the old jail was found to be cruel and unusual under the 8th Amendment. So how do they build a jail? How do they create a school district? Because the legislature has failed to act constitutionally.
Right, and I might also add that some of the United States Supreme Court decisions guided, or at least were the backdrop for this case that we are referring to in the state. Now, mind you, I've only talked about the federal side of things, the U.S. Supreme Court. We haven't yet talked about the state Constitution and the provisions that were involved in that case.
And when I was just, we're probably ahead of ourselves, but that happens all the time, behind ourselves and sideways. The Pennsylvania legislature was extraordinarily angry with me, with the Pennsylvania Supreme Court. There's 7 of us, but I was among them, to the point that there was a resolution introduced to impeach the 5 Democrats, and I was among them. Although I don't view myself as a Democrat, I view myself as a judge, and we can talk about that. But in any event, there was an irony to that because I was in dissent on what they were angry about. I wasn't even in the majority, and they actually withdrew it against me. But I got a kick out of it. I have the impeachment framed, and
He does, in his
my
office.
I'm very proud of it. I wanted T-shirts made if any of you created the great impeachment of 2018. But in all seriousness, what made the legislature angry was not the finding of unconstitutionality. It was what we just went over, and what I just explained. They felt that the majority of the court, and it wasn't in it, did not give them a fair and adequate time to redraft the congressional districts before the court took it from them and put its own map into place. Now, they're entitled to that opinion. You know, that's our First Amendment rights, and the majority of my court are fine people doing a fine job, and they felt that they gave them an adequate time. It was about a month, I think. Might have been a little longer than that. Frankly, my dissent was that that was an insufficient time. My view, and again, no criticism of the majority. I'm in dissent every day. It's just part of the process. But my view was that the legislature could not do a proclamation congratulating mothers on Mother's Day in a month. It's just not how legislatures work. And so I felt that we had to give them an extended period of time.
So back to the federal side of things and then moving into the case itself, because it was a very interesting process. Federal side, for those of you that have taken any kind of course or listened to any lecture on voting, you've heard the case Baker versus Carr, right? In the 1960s, I believe it was 1962, the Supreme Court came down and said the Constitution requires one vote for one person. per one person. And what had happened was many of the states had not changed their voting processes from back when they were very baby states and the cities were not full of people and the countryside ruled the roost. And then you take it up to the mid-1960s, and the cities just didn't have much of a vote. So the Supreme Court came down with Baker versus Carr, and a couple of cases thereafter said this applies not only to federal congressional candidates, it also and elections, but also to states. So that is a context. That was not one of the issues that the court needed to decide. It had already been decided.
And the key to Baker versus Carr is extraordinarily important, and important today as well. There's something called the political question doctrine. Any of you ever heard of that? What that says is that judges do not make policy. Judges apply law to facts and decide cases. A political question is a question which is so intertwined with politics that it is better left to the executive and judicial and legislative branch, and the court should decline to hear it. The first case that declared a political question was Otjen, O-T-J-E-N, I think, versus Central Leather, if memory serves me, 1918. Somebody sued because they wanted to alter the United States' foreign policy just after World War I. And the court said, the U.S. Supreme Court said, we are not getting into that. We do not do foreign policy. Foreign policy is for the executive branch, and it would be inappropriate. Right. Another example is I'll mention one other one for you. Nixon versus the United States. President Nixon, as he was in deep trouble, some of you are old enough to recall that, sued to change the process by which impeachment would go forward in the House of Representatives. The United States Supreme Court said the same thing. You know, they said substantially, are you out of your mind to ask us to get involved in that? And that's inherently for the House of Representatives. Now, they may have said something differently if there was an argument for a deprivation of due process or like, but they were arguing about administrative proceedings. Now, I'll mention one other case to you, Bush versus Gore. How many of you thought about that one? Nobody on the U.S. Supreme Court seemed to be inclined to write that that was a political question. Who's going to win the presidency of the United States? In my view, it was a political question, and that court should not have gotten involved. It got involved. It voted on partisan lines, and it made Bush president. Now, I frankly don't care about that. I don't care about the politics of it. I don't think that was the case. And there have been many, many scholarly articles since then. One that I recall distinctly, Duke, I guess it doesn't matter, but Duke Law Journal written by Erwin Cherminsky, who's one of the most prolific scholars in the United States and one of the most often cited scholars. He's the dean of University of California, Berkeley Law School. And he said, political question, there's just no question about it. The court was out of bounds to decide. So that's a political question. And the reason that I explain that to you, first is, you should, if you go home and you don't understand anything else, remember, courts should not do political questions.
What is it about apportionment method
Yeah.
that makes it not a political question?
Well, because the Constitution says that it's a legislative decision. And we have the three branches of government, okay? Legislative, executive, judicial. As the Justice said, judges decide cases, but they don't make the policy decisions that go into how districts are drawn. That is legislative. You'll often hear the term justiciability. That's what we're talking about here.
The opposite.
Well, that is the opposite,
not
but
a
the
political
question,
question,
it's
it's
justiciable. So when the cases are saying it's non-justiciable, that means it's political. So just to complete the case law, so we have an understanding of what that context is, Baker versus Carr, one person, one vote. We go through a couple of other cases. We get to a case called Shaw versus Reno. Racial gerrymandering is always verboten under the 14th Amendment. So if the case involves racial gerrymandering, in another way, the cases will be addressed by the Supreme Court. And then you get to a case called Veith versus Jubileer. And in Veith, we had an interesting array of opinions. And the opinions basically came down to sometimes extreme gerrymandering may be justiciable. Claims of extreme gerrymandering may be justiciable, assuming that the person has standing up before the court. However, we don't really know what the appropriate remedy should be. Now, this was a case decided in 2004, and this kind of gives you the backdrop, not only to the state case, in a sense, but also into the kinds of questions that we're considering as citizens right now.
And let me supplement again, because I think it's extraordinarily important and worth saying. And Mary Jo, you asked what makes it judiciable or justiciable and what makes it a political question. The answer is that where you draw the line is the great mystery of the law, and that's why votes are 5-4 on my court 4-3. So in Jubileer, Veith versus Jubileer, right?
Veith.
Yeah, in Veith, 2004. Chief Justice Roberts, Justice Alito, Justice Thomas, and who else was there besides
Kennedy.
Gorsuch?
Kennedy.
Not Kennedy. Who's the fourth? The fourth conservative justice, and I'll think of him.
No,
Was it?
Scalia.
Oh, sure,
Thank you.
Tony Scalia, one of our best friends, a flamboyant guy. All said.
Actually,
in
he
fact,
was a friend of our law school. Yeah.
He was the world's nicest guy.
Yeah.
Nicest guy.
Yeah.
He could do without his writing. I'm teasing. I'm teasing. Those four said, in fact, political question, non-justiciable.
Right,
This
non-justiciable.
is just too much for the judiciary to try to get into and divide these lines. On the other hand, Justices Ginsburg, Breyer, Kagan, and Sotomayor said absolutely justiciable. Therefore, it came down to Justice Kennedy. And so many cases came down to Justice Kennedy. And what he said is, and Maureen alluded to this, I just wanted to make sure it was clear for you. He said, I think it's justiciable. I see no reason why the courts can't step in and get involved if the people are being deprived of either their First Amendment or 14th Amendment rights. However, I'm not going to vote to overturn this as a racial or an extreme political gerrymander because I don't see a manageable standard. I can't stick my hand into the air and say, well, that smells bad, that feels bad. That's no way to decide a case. There'll be thousands upon thousands of these cases. We need to have some standard to decide, to put the law, to put the facts against in determining whether or not it's an unconstitutional or constitutional gerrymander. And from that moment on in 2004 until 2018, when the various cases, which we'll get to, have been decided, the task of the anti-gerrymandering faction has been to devise manageable standards. And Carnegie Mellon University has been at the forefront of doing that. And in fact, has had its professors testify and have signed on to amicus briefs all over the United States. You should all be very proud of that.
Very true.
So, Justice
Does that answer your
Baer, you've brought us some great slides to tell us what gerrymandering is, and how would you describe it?
Gerrymandering is the drawing of legislative districts to advantage your, quote, side, end of quote. Be you a Democrat or a Republican, it doesn't make any difference. Both sides absolutely do this. And to disadvantage the other. And did you all get this? Most of you get these? Okay. So let's look at them quickly.
And we've got them up here for you.
Oh, and we have them up behind us? So you have a mythical jurisdiction, 100 voters, 60 Orange Party, 60 Green Party, okay? If you just divide them, 60-40, which is the bottom chart on the first page, certainly not unfair. No real representative democracy there. You have the Orange Party controlling 6 districts, the Green Party controlling the 4 districts. So you don't have meaningful elections except in a primary. But as importantly, In other places where you have other parties, Italy in particular, but a lot of the continent, lots of different parties win seats, and therefore you never get a majority government. And it's worth saying that's why the United States did not do that. Flip the page for a second. All right, this is gerrymandering. Again, if you learn not to, this is gerrymandering. So look at the top. Assume that the Orange Party has the governor, has the House, and has the Senate in your state, okay? It can do what it wants. It has unbridled power. So it has taken its 60% of the votes. It has arranged its district 6-4, all 10 districts. Are you with me?
That's the legislature that has done that.
Under the federal constitution,
Under the federal-
that's the legislature. Now, in Pennsylvania, it requires a statute. Therefore, the governor signed off. Now, if we get into the weeds a little bit, in 2010, we had a Republican House, Republican Senate, and Tom Corbett was the governor. And that's what we found was unconstitutional, is gerrymandering. So here, unless a Green candidate can get better than 11% of the Orange candidate's voters, they can't win. And the reality is you can't do that. In the 60-40 district, the minority candidate is probably going down. So look then at the last one. Here, the Green Party, for whatever reason, was able to win only 40% of the vote, right? But could put in its own gerrymander. So what did it manage to do? If you, and yours are not numbered, but if you look at this top left, you see a district, it's got 10 Orange candidates. See that? Mm-hmm. That's packing. Remember that word. This is all about packing and cracking. Then if you look at the next district down, 10 Orange candidates, packing, right? The Green candidate is giving them these districts, but they are packing them so that they're getting rid of that 60% majority in these districts so that they can control other districts. Go down to District 3, 10 again. So they're giving 1, 2, and 3, and 4 to the Orange Party. Why? Because they want 60% of the vote and they want to get rid of them. So come over to the right, and you can see that district is 6-4 Green. And if you go down the page, there's 7-3, 7-3, 7-3, and 6-4. And you can look at that later, trust me, because time is limited. The Green Party managed through gerrymandering to win 40% of the vote in this district, but to control 60% of the seats. Anybody think that's fair? That's what's going on out there every day.
So let me also give you two other ways that state legislatures can gerrymander. One is called hijacking. And hijacking is to redraw two districts so that an incumbent in one district must face an incumbent in the next district, in the redrawn district. That's called hijacking. Kick out one of the incumbents, merge the two districts because you've redrawn your districts, and make them fight each other. Usually two R's fighting each other or two D's fighting each other, okay? That's called hijacking.
There's only one congressional district in the United States that has pitted two incumbents together. Anybody know where it is? Keith Rothfuss versus Connor Lamb, South Hills of Pittsburgh.
Yeah, right. And then the other is, and this is devious, kidnapping, they call it. And kidnapping means you move the incumbent's home address into another district. So you have to live in the district that you represent. And if the redrawn map moves your address into another district, you can't then be elected in the district you formerly represented. That's called kidnapping. So we have cracking, we have packing, we have hijacking, and we have kidnapping as 4 different ways of achieving a gerrymander.
And let me just briefly, I'm going to do this briefly, I promise, Mary Jo, tell you where the name came from. And the reason is that we're looking at the slide. So look at page 3. You see what looks like Smog the Magnificent, for you Lord of the Rings fans, circling this district. All right. So Eldridge Gary was actually a great, great man. He was the governor of Massachusetts at this time. His legislature, in accord with the federal constitution, put together this as a gerrymander because they wanted somebody to win or lose that district. He was governor. He signed it, and I'm sure there were politics involved. I don't know what he got or didn't get, but he signed it. So a guy named Mr. Teasdale wrote in the Boston Gazette and called that a gerrymander because his last name was Gary. Now, Gary went on to sign, he signed the Declaration of Independence, and this is probably why he's the best man in my estimation. He refused, he was a member of the Continental Congress, he refused to sign the federal Constitution because it did not contain the first 10 amendments. And he was afraid of the power of the federal government that was being established without the protections of the first 10 amendments. So he wouldn't sign it. He went on to be James Madison's vice president and died in office. So a great man, but unfortunately, this went from Gary to Gerryman just because people couldn't pronounce his name. And today, when we talk about Gerryman, I wonder what he would think if he knows that's what he's famous for in 2020. But that's where it comes from.
So if you want to see what was in front of the Pennsylvania Supreme Court, we're going to look at the next slide. And the first we can look at is over here in the District 12. If you just look at it, covered Beaver County, Allegheny County, down to Somerset, Cambria County, a little bit of Westmoreland. It looks like a big hammer, doesn't it? Now you're thinking, well, what are the standards a state legislature should use in drawing the districts? Well, the Supreme Court has come out, and basically the language is that the district has to be compact, contiguous, equal population, and respectful of township, county, city lines. Respectful. But you don't want to have racial gerrymandering. You want to be cognizant of the Voting Rights Act and other things. But this concept of compactness and contiguousness. Why? Because you're representing an area, and usually people of similar concerns will want a representative representing those similar concerns. Let me give you an example. Say you have a concern about a certain polluting company in your area. Well, you would like that the representative represents that area and doesn't have an area that is strung just across 4 or 5 different county lines. So that is the backdrop to compactness and contiguousness, equal population always, and a concern for already established municipal lines. So
and interestingly,
okay.
And we should, again, there's just so much to tell you.
Share with you.
The federal Constitution, you all know, is a few thousand words. State constitutions are enormous. And there's reasons for that, but I don't think we should get into that today. But among the Pennsylvania Constitution, and it's about 89 pages as opposed to 5 for the federal Constitution. The Constitution of Mississippi is 600 pages, so they vary. But Article 2, Section 16, the Commonwealth shall be divided into 50 senatorial districts, 203 representative districts, which shall be composed of compact and contiguous territory, as nearly equal in population as practical. Long before Reynolds versus Sims, we said that in our Constitution. Actually, that's not true. And then, unless absolutely necessary, no county, city, incorporated township, borough, etc., shall be divided. The reason I said that's not true is this Constitution was written in 1968. Reynolds versus Sims was actually decided in 1963. Therefore, they may well have known that and put that in for that reason. I don't know that. I've never gone back and read the reports from the Constitutional Convention. But in Pennsylvania, we know we have constitutional direction, again, intent, as to what should be applied. And those are universal subjects. Just one other quick comment. They do not help with gerrymandering. You can draw a map that is compact, contiguous, relatively equal population, and doesn't necessarily
lines.
break up everything, and it can still be a gerrymander.
Right.
So that doesn't really answer our question.
But those are some of the articulated standards you see in courts.
They're the neutral standards universally applied by everybody all the time. The difficulty is they don't answer the query we're here today to discuss.
And I might just also mention Article 1, Section 5 of the Pennsylvania Constitution. Now, interestingly, the U.S. Constitution, of course, was passed after the Pennsylvania Constitution. Pennsylvania adopted its first constitution in 1776, and we didn't get around to establishing the federal constitution until 1789. And the way that our government was formed in Pennsylvania became a guide for the way government was formed under the U.S. Constitution. In Pennsylvania, we had a Bill of Rights that is the first article in the Constitution. The Bill of Rights in the federal Constitution comes as the amendment. So it's very interesting to see the comparisons and the contrasts. But many, many feel, certainly those of us in the judiciary in Pennsylvania or used to be, that we were the pro forma for the federal U.S. Constitution.
And again, I hope I can do this succinctly. That's equally true for the Pennsylvania Supreme Court and the United States Supreme Court. Pennsylvania Supreme Court was established in 1722, maybe 1688, but 1722 is on the seal. In Philadelphia, obviously the cradle of democracy. The U.S. Supreme Court was founded in the United States Constitution in 1789, some 67 years later, in Philadelphia. And the Pennsylvania Supreme Court was there and sitting, and the members of the Constitutional Convention, and Ben Franklin, and John Adams, and George Washington, they were all close friends with the people, the erudite aristocrats sitting on the Pennsylvania Supreme Court. So as they're drafting Article 3 of the federal Constitution, which is the judiciary, they're looking to this 67-year-old court sitting in the same city for advice. It's interesting.
Right. So Article 1, Section 5. Here's what Article 1, Section 5 of the Pennsylvania Constitution says. Elections shall be free and equal, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage. Very simple statement, isn't it? Elections shall be free and equal, and no power can interfere with the right to vote. That then begat the case. And frankly, in my view, the case is built on a fundamental principle that votes should not be diluted. And one dilutes the votes when one has a gerrymander, when one's district does not fairly represent what is in that district in terms of the way the district is drawn.
So I'm sorry, the case came to the Pennsylvania Supreme Court.
That's right.
And how did it get there? And the case is League of Women Voters and a lot of other petitioners who have a stake in the case versus the Commonwealth of Pennsylvania and a lot of Pennsylvania officials who also had a stake in the outcome.
And I'll be glad to answer that. And then I think we should probably move on because we're not going to get to the legal criteria for gerrymandering, which is too bad since you're all here to hear about gerrymandering. The case got there because the League of Women Voters did a brilliant job as the plaintiffs. They got 18, and again, I'm going to digress for a second. They got 18 representatives, plaintiffs, out of the 18 congressional districts. The reason that's important is you've heard us talk for a second about Gill versus Whitford, which is the Wisconsin case that was before the United States Supreme Court with a manageable standard so that Justice Kennedy could finally vote. That case was dismissed 9-0 by the United States Supreme Court because they found that the plaintiffs in the case did not have standing. And I think that's worthwhile mentioning to you for 1 second. Standing, you have to be aggrieved. They brought that case, and the way you bring a case means everything, which is what made me think of this. They brought that case under the 14th Amendment. They said there's two classes, either Democrat or Republican, or the people from Milwaukee and the people from somewhere else in Wisconsin. Sure, there's another city. Who knows a city in Wisconsin? Madison, thank you.
Good.
Absolutely. Fine school. They said you can't show that if you are a representative of Milwaukee, that you somehow are being deprived of equal protection vis-a-vis an election going on in Madison. It's too attenuated, it's too far, it's not there. And they decided at 9-0. So they said they don't have standing. And then I'm going to come back to our case, because the reason I thought about that, in our case, they avoided that by getting one representative from every district. They did remand Wisconsin's case, and it's actually going to trial relatively soon, and one of the issues is, are they aggrieved? However, Justice Kagan, and I love Elena Kagan, love her. I think she's the smartest of the smart. And she wrote a concurring statement, because it was 9-0, and she said, gentlemen, ladies and gentlemen, you did this wrong. Don't bring this under the 14th Amendment. Look at the problem you have. Bring it under the First Amendment. And that's where you argue vote dilution. You say, I have a constitutional right to associate with people in Madison, but I'm from Milwaukee. And that's being disenfranchised. I am not able to associate with the people I want to. I'm not able to join together with people across the state. And my vote is being held captive to this. And if you had brought this under the First Amendment, you would have had standing. And that's important, because the court acts upon its pleadings. So with all of that as a quick segue, the League of Women Voters was the named plaintiff. They got 18 representatives. They did a brilliant job. They filed in the Commonwealth Court. That was a tactical filing. They could have styled their case and started in the trial court. The reason, I don't know this. I mean, I'm surmising this. I don't have a personal relationship with them. They never talked to me. I just decide the case. I think the reason they did that is, if you start in the Commonwealth Court, number one, you're going to get a fine judge. And they had Kevin Robson, who's a brilliant judge and did a fine job in the case. But beyond that, you have a right to direct appeal to the Pennsylvania Supreme Court. Right to direct appeal. If you begin in a trial court, you have a right to direct appeal to the Commonwealth Court. But you have no right to appeal to the Supreme Court, to my court. My court would have to agree to hear it. And so and that matters. So I think they wanted the Commonwealth Court as a court of original jurisdiction to make credibility findings, which are binding on an appellate court, and they wanted our court to have to hear it. Frankly, we would have heard it anyway. But they wanted us to have to hear it. So they took an appeal, and we heard it and decided it.
Right. So I just want to tee us up a little bit for some of the tests that have been articulated recently as ways to demonstrate unlawful gerrymandering, or ways to create districts that are, for lack of a better word, using all these standards, fairer, okay? So just want to complete. You see that purple over there? Is that the gerrymander? No, it's the green underneath the purple. District 7. It's kind of hard to see from here. District 7 is Mickey and Goofy kicking Donald Duck. Yeah. There we go. Goofy kicking Donald Duck. Now you see that teeny tiny little spot there connecting the both? Do you know it is just, what, half a highway? It's just you cross a highway. It's 100 feet.
Anybody ever drive from anywhere in Pennsylvania into
Montgomery.
Philadelphia?
It's Montgomery County, yeah.
Through Valley Forge.
For Valley Forge.
As you're getting off the Pennsylvania Turnpike, you see down on your right side. We do this all the time because we ride the circuit and sit over there. You'll see down on the right side Creed's Restaurant. There's a picture of Creed's Restaurant in your handout. That restaurant, that building, is the size of the connector that makes this district contiguous. So if you sit in one half of that restaurant, you're on one half of the district, the other half, the other half. I must tell you, during oral argument, to try to prove the absurdity of arguing that that was contiguous, I asked the lawyer, assume that I put a district together and it's Pittsburgh and Philadelphia connected by the Pennsylvania Turnpike. Would that be contiguous? You know what he said? Yes. He said yes. And I said, I congratulate you for sticking to your position.
So if you go to the next slide, it shows the map that eventually resulted from the case. And you see the standards of compactness, contiguousness, equal population, and respect for municipal lines, a lot more clearer here than you would have seen in that prior map. So you might ask, well, how did you get this map? How did this get created? And it was very interesting when you read the case, which is 160 some pages. So it really takes, endurance to read the case because you go through all the evidence that was considered. But many of the pieces of evidence were models put in by statisticians and mathematicians, and algorithms that were designed to test different prospective plans.
Just to keep this all coherent, recall in Veith versus Jubileer, Kennedy said, give us manageable standards. These are the manageable standards that people went out to get to try to stop gerrymandering.
Right. And there was also testimony from other parts of life, political scientists and things like that came, testimony like that came in to the case. But your own professor, Wes Pegden, was one of the highly respected participants in the expert testimony that came into the evidence.
So let's just, before we run out of time, to prove an unconstitutional extreme political gerrymander, you have to prove three things. You have to prove discriminatory intent, discriminatory effect, and that there's no other basis upon which this district could have been drawn, that it's not a question of the Rocky Mountains between two places or a lake or the like. Discriminatory intent, effect, and no other basis. If you prove that, you can prove an extreme political gerrymander. However, that still doesn't answer the question, and that's what Maureen was just talking to you about. To prove that, you need some objective standards, because again, if you think about it, how do I prove the discrimination? I can't just say so. I can't say it looks bad. I can't say it looks like that. So there's 3 tests, actually 4 tests, and Maureen will talk about some of them, and I can too. Markov's chain. Markov was a Russian mathematician, Professor Pegden of Carnegie. Is that how?
Do I pronounce that right?
Okay, of Carnegie Mellon came up with this. And the theory is if you move one line a little bit and you get a pronounced change, that shows that there's a unconstitutional gerrymander. Now, if you just think about this like a layperson, it makes sense. If you look at these districts we just went through and you have them packed, if you move one line, you're going to move some of the packing into another district or some of the cracking into another district, and you're going to get a profound change. And he ran 1 trillion maps. Now, he did not actually run them. He didn't print them out. He didn't have the computer memorize them. But he was able to come up with a mathematical theorem. Love mathematicians, don't understand it at all. But a mathematical theorem that proved his point. And also, interestingly, and I'm not sure this was in the record in Commonwealth Court, he has another theorem that proves that you can be compact, contiguous, and equal population and still be gerrymandered. And he can show you how to draw
Let me
those.
talk about that one.
Sure.
He calls this the test every one of us learned when we were kids. It's called eat the cake test. And you divide up Pennsylvania in 18 districts, and your friend gets to get the first piece of cake. Freeze that, redraw the other 17 districts. I get to pick the district I want. You know, you cut the cake, the other person gets the piece, that kind of thing. And they did a mathematical modeling of that, where the one side draws the line, draws the state, and the other side gets to pick one district and freeze it. Then you redraw the next set of 17, and then the other side does, then I get to pick. And so we keep freezing these districts that were population equality. And he ran the mathematical model on it, and it's sustainable. He said it works. And it's a simple way of dividing up the state. So we'll see how many state legislatures use that method, but I think it's very interesting and fundamentally fair, as takes a lot of the politics out of, well, a lot of the bad politics out of, yeah.
So there's 2 more tests that have been developed and have put into evidence and have been successful in proving a extreme partisan gerrymander, unconstitutional gerrymander. The second one, not in any given order, is the efficiency gap. What you do is you take the number of votes that are wasted in any given election. So one candidate prevails. The Republican candidate prevails 80-20, or the Democrat. It doesn't matter. Again, I emphasize that. So 100 votes, 80-20. It would have taken 51 to win that district since there were 100 votes. So from 52 to 80 are wasted, and all the other votes are wasted. And you take the majority votes, you subtract the minority votes. I did this; it actually does work. Minority votes, you divide it by the total number of votes, and you get a number, and that number ought to be less than 10. If that number is a 10 or greater, then that's evidence of a gerrymander. And for those of you who actually care, go home and work on it. You'll find that it works. It ought to be 2 or 3. And in Pennsylvania, that number was sky high, and that allowed these experts to say there's no question in their expert minds it was a gerrymander. Then the third test, and there's 4 tests. One is cut the cake. The second is the Macroft chain. The third is the efficiency gap. And the fourth test is the mean medium test. And again, these all make intuitive sense for those of us who are logical but not mathematical. The mean medium test says take all the districts and line them up, all 18 in Pennsylvania, and see who won what by how much. And then take and average that, okay? So take 18 districts, who won by how much, average that, and see what that number is. And that means that, let's say in Pennsylvania, that's a fact, the Democrats carried 6 of 18 districts with 53% of the vote. Not unlike what we showed you, right? 53% of the vote, 1/3 of the seats. And then take the exact middle, which is the mean, right? I think that's right. That's the medium. Thank you very much. That's the medium. You can see I'm not a mathematician. And that was 47.5% in Pennsylvania, I think. And I may be off of my numbers. I apologize. I actually have it somewhere in this mess. And the fact that the average vote gotten, the median vote, is 47.5, but the average, the mean, is 53, shows that there's a gerrymander. And I'm not sure that I explained that very well. It does make sense. And so those are the tests that Kennedy's asked for. Those are the tests that the social scientists, the mathematicians figured out. Our university communities figured out. Took to the lawyers. They said, we'll run with it. They filed the lawsuits. They brought them. They built the records. And Dr. Pidgeon did testify in the Commonwealth Court on Macroft chain. And what did they prove? What do they have to prove? Discriminatory intent, discriminatory effect. They were able to prove this through these tests, and no viable reason for it. Ergo, an extreme political gerrymander turned away by the courts. However, the big prize has eluded them. It's not yet been ruled that justiciable. It's actually not even justiciable anymore in the U.S. Supreme Court, because it's 4-4, and Justice Gorsuch has not weighed in, but trust me, I know where he's going to weigh in. And Justice Kavanaugh has weighed in, and it has not weighed in, and I don't know where he'll weigh in. But I would not be optimistic if I was a plaintiff's lawyer, a civil libertarian lawyer trying to attack a gerrymander.
Do you think that's why we'll see more state cases?
Just was going to say that.
Inward to our state constitutions rather than for relief in the federal court?
We've
typically gone for constitutional relief.
I would say that is absolutely what we're going to see, bringing a lot more vitality in the state constitutional mechanism, particularly for the representatives that, not only congressional representatives, but representatives to the state legislature.
And it's being attacked in other ways. Tomorrow, incidentally, happy Guy Fawkes Day.
That's
5th
right.
of November.
That's right, it is.
Tomorrow, 4 states, Colorado, Iowa, and 2 others that I'll find, have on their ballots propositions to take this away from the legislature and give it to independent commissions. That doesn't make the independent commissions, based upon what we know, necessarily a foolproof method, but it's a preferable method to having legislatures do it, because legislatures are political. And we know that. They were just as political back in 1789. And that's one of the arguments against that gerrymandering should be okay, because that's where the U.S. Constitution put it, in a political body. But 4 states are doing that. Pennsylvania does not have a right of proposition, a right of referendum. You can't put a ballot initiative on our ballot. It's not in our Constitution, and my court has never said you can. Frankly, I don't think it's a good idea. but it is frustrating when it comes to this. And I say it's not a good idea. If somebody brings the case, I'll rule on it. I don't mean to say that I would vote against it. You have to brief it, you have to argue it, and you have to let me look at the law and decide it.
Justice Baer, you concurred and dissented from this opinion, and you talked a little bit about that at the beginning. Could you finish up with telling us your thought process in terms of how the map was created and when it was going to be effective? Because this is our map for tomorrow.
Yeah, exactly. And again, that's the reason that Rothfuss and Lamb are against each other, because my court redo the districts. Here, and I have alluded to this.
Wasn't that just a timing question? You decided on the timing?
Yes, exactly, precisely.
Were there two decisions?
No, there's one
Yeah,
decision.
we'll take questions in a sec.
Although I'm glad to respond to that. I thought it was an easy question whether this was an unconstitutional extreme political gerrymander. It was a 5-2 decision of my court, and again, no apologies for that whatsoever. I would vote that way all day long. Then the question came to remedy. We've already talked about the federal Constitution saying that the legislature has the opportunity to do it. My view, and the majority's view, is that we should not do this as a correction of a constitutional wrong until the legislature has a fair chance to fix it. The majority felt that a month was sufficient time for the legislature to fix it. I felt closer to a year, and I've already said that. Therefore, my vote was that find it unconstitutional and implement the new districts in 2020 rather than 2018. I didn't think that we had given the legislature the fair opportunity to change the districts. Now, I didn't love that decision from a personal viewpoint because these are unconstitutional districts. Yet there's lots of precedent of using unconstitutional districts so that an election can go on where you don't have any time. And if I was going to level criticism, and it's constructive criticism, it would be on the plaintiffs who could have brought this suit in December or January after the prior election and waited till June, I think June of the following year. And those 6 months were crucial. We didn't have time to get this done. So I was in dissent on timing. It didn't make me happy. I'm happy these new maps come in as an individual. But as a judge, I thought we didn't give the legislature enough time.
And before we take questions, Dean Lally-Green, can I ask you just to sort of talk just briefly about the importance of the independence of the judiciary, its role in protecting the vote, and maybe generally what you think about the vulnerability of our ability to vote?
I'll do the last question first, and I'll end with the importance of the judiciary. We spent a lot of time today talking about gerrymandering, but the bigger question is the vulnerability of the vote. And whether we are talking about hacking from outside sources, from governmental sources, we're talking about voting machines that are too old, that they're not properly calibrated or keeping records. You know, some of the voting machines, not in Pennsylvania, but across the nation, don't even keep a good record of the votes. These are systemic issues. There's also the partisan language that we, not the partisan language, but the context within which we discuss issues, that we've kind of gotten away from a civil discussion and discourse about really, really important issues. These are all part of the duties and rights of being a citizen. You know, that we have to be engaged, but we're concerned about the quality of the vote. Now, to the role of the judiciary. In my view, I gave that picture of the triangle, the checks and the balances of our government embedded in our Constitution, and certainly something that we really respect, we try to respect as society. Allowing, as Justice Baer has said, the rights and duties of certain branches of the government to do what they do, and a careful check and a balance. But the last word by Marbury versus Madison, and something we live with, is the judiciary. Therefore, the quality and the integrity of the judiciary is incredibly important, and the independence.
And I think in closing, let me just say, first of all, the 4 states that have ballot initiatives tomorrow to change from a legislature to a commission are Michigan, Colorado, Ohio, and Utah. And Ohio's close, so we can all watch and see what occurs there. I am greatly concerned by both political parties, or either political party, engaged in voter suppression. And there's no question that that's going on. And I want to give you a closed chapter in closing. During the race between Obama and Mitt Romney, 2012, I believe, Pennsylvania passed a voter ID act. Now, there is zero evidence of any voter fraud ever in Pennsylvania, and indeed anywhere in the nation. No voter fraud. You know, President Trump saying, well, he would have won except for that massive fraud, the popular vote. Obviously, he won the electoral vote. It's just not so. And I'm not playing politics, I'm just saying that. So we passed the voter ID law. Now, it was the most conservative voter ID law in the United States. CMU students, you were not permitted to use your IDs as a valid form of identification. Now, why not? Because the party in charge of it didn't want you to vote, because you're a bunch of wild-eyed liberals. Again, they didn't want poor people to vote. They didn't want aged people to vote. They didn't want immigrants to vote. And Mike Turzai, who's a fine man, a fine state representative, and a friend of mine, but nevertheless, Mike Turzai stood up in front of the Republican State Committee and said, because they passed that bill, Mitt Romney would prevail in the presidential race. That's what it was about. Now, it came to our court, it went back to Commonwealth Court. Suffice to say, it did not go into law. And when that presidential election was over, they abandoned even trying to pass it because they didn't care. They cared about that presidential election. But that's voter suppression, and that's the point. And again, both parties are willing to do it if they think they can, and they can therefore prevail. Politics is a deadly serious business as to who's going to run our country. Are we going to build a border wall, or are we going to fix our aging infrastructure? Are we going to fund the military, or are we going to fund our school systems? So this is not a game. It's a deadly serious business. Both sides deeply, honestly believe they're right to some extent now, and this is the partisan divide that's so bothersome. They think the other side is out of their minds and in a clear and present danger to the future of the country, and so they're playing for very high stakes. And I suppose they would tell you that the ends justify the means.
To the victor go the spoils.
And to the victor goes the spoils.
And our
Andrew
courts
Jackson.
are our firewall against that.
Our courts are.
Well, that's right. If you're poor, if you're unpopular, if you're dispossessed of any political power, and you need justice, you come to the court system. And we'll hear your case, and we'll decide. Let me say one other thing. However, having said that, courts are reactive in nature. Courts hear cases brought to them. The only reason that we threw out that map in Pennsylvania is the League of Women Voters and those 18 plaintiffs brought the case to us. Other than that, we can't reach down and take the case.
And with that, let's take some questions. Sir.
So I'd like to first mention that one of the plaintiffs from Allegheny County is here, Kitsy McNulty, and also Alan Freese is the senior author of on the Pegden paper. That Alan's right over here.
Right there. Nice, thank you.
Great job.
Great job, yeah.
So
You could have explained it much better than I could.
that's right. But I did have a longer question or the comment here. So Justice Baer, you wrote a very interesting opinion on the case, and as you've already mentioned, you dissented and you concurred on different parts of it.
Before I came here, but go ahead.
And you've already mentioned about the timing issue. I disagree with you on that one, but the one I agree with you on was the issue of the court setting the criteria for the new map. So as maybe, I'm not sure whether you mentioned it, but there is no criteria in the Pennsylvania Constitution regarding the congressional map. There are the criteria for the legislative maps, but not for the congressional maps. And you said that that was wrong, that the court should impose its criteria on the drawing of the new map. I tend to agree with you on that, because you also wrote that this language, and I'm quoting you, this language obviously does not address the size or shape of districts. Moreover, there is nothing inherent in a compact or contiguous district that ensures a free and equal election. And I have done an analysis of this map and a whole bunch of other maps, and I believe that they're all still biased in favor of Republicans. Not as badly as the original 2011 map, but they're still biased. Okay, I can share my analysis with you at a later time. But if that's the case, then and let me also mention that one can use election data to test, that's what I've done, to test whether a map is biased. So my question, finally a question. Given the free and election clause in the Constitution, which free and equal election clause, wouldn't it have been better for the court to have taken fairness as the criterion rather than compactness and not splitting boundaries and things like that?
You know, you're obviously extraordinarily erudite and have thought about this a lot.
Well, I'm a CMU professor.
And I say this with the greatest respect. You remember when I said in Fife versus Jubileer that Justice Kennedy said, you have to provide manageable standards, ergo, the Makarov chain, efficiency gap, etc. I think if Justice Kennedy was here today in responding, he would say that fairness is too amorphous, too subjective, and therefore is not a standard that a court would feel comfortable, or at least the United States Supreme Court, not speaking for myself, that I would feel comfortable use it. Now that doesn't mean you couldn't put meat on those bones and satisfy me, but just the idea of fairness I think is so subjective. But
The criteria that were used that you agreed to are essentially testing fairness. The efficiency gap in particular.
I think that's fair. I think that's accurate. And I think these other tests, including the test that Dr. Friesen came up with, all are for, in the bottom line, to test fairness. But they test them through mathematically proven, discernible, objective ways. And I think that's what was required by the U.S. Supreme Court. And I frankly think, but for that, my court may not have done what it did.
But we have that now, so shouldn't we go forward and use what the political scientists and the mathematicians have come up with in order to draw better maps?
I think the answer to that is yes. But remember, that's a legislative function, and we review for constitutionality. But I think so.
Well, I'll just also say that on that, it's going to be a lot of what I have read about mathematical modeling, and a lot of the modeling here came right from this university in that case. But there is another side of that, which is what is in the mathematical model, and understanding the model itself and the algorithms used to test the data and all of that, some of the biases that can be in the algorithms. So we still have a way to go. On the other hand, this case was a pretty sound case.
And I think this may be of universal interest. When we did the state redistricting, and a commission did that and came to us for review, a citizen fed data into a computer and came out with a map. And it was seductive because it seemed to meet all the criteria. But I've sort of changed my mind in that regard. I'm not convinced that map was good. I'm not convinced that it took into account boundaries between municipalities, natural boundaries, rivers, mountains, and the like. And this is very controversial, but it took no account whatsoever of incumbency. And there is some strain in the cases that you consider incumbency as not as a matter of protecting these people for their jobs, but as a matter of maintaining the representatives for the people they represent, and not having a lottery and changing those every 10 years.
And the courts don't get to make that up. that a record has to be created with witnesses and experts, and the court then decides which expert to accept. So the court can't make this up on its own, I think.
Yeah.
We have another question?
Sure.
Oh,
Thank you, sir. Thank you.
And that's the due process clause.
Yes.
yeah, I was just wondering if you could give a few examples of both sides gerrymandering for their benefit.
Well, we've talked a great deal about Republicans gerrymandering. It was the Republicans that did that in Pennsylvania. But at the same time, the Wisconsin case, which was a Republican gerrymander, was going to the U.S. Supreme Court.
Maryland.
Yeah.
Maryland.
Besnick versus Lesniak, Maryland, a statutory court, a three-judge federal court, threw out a Democratic gerrymander, and that continues to pend below. The U.S. Supreme Court has not yet heard that, but the Maryland federal court is sticking to its guns that was an unconstitutional Democratic gerrymander.
So it is both ways throughout the, or it could be argued it's both ways throughout the states.
One of the reasons that you see a fair number of Republican gerrymandering is when Obama, and I mentioned this, when Obama won in 2008, a bunch of Republicans, strategists, professionals, said, you know, our party's been set back 25 years. They said, they figured out how to get it back. They raised $35 million. This is recounted in a wonderful book called RATF''KED. I guess they didn't want to put that profanity on the front of a book.
And neither should you.
But you should get the book. You should get the book and read it. They got $35 million. They targeted seats in various House and legislative bodies throughout the United States where there was Republican governors. They won those House and Senates, and they won Pennsylvania. We're the first chapter in that book. Then they redistricted, because you can't redistrict. You can't do what we're talking about if you got a Democratic governor and a Republican House. If you got a Republican House and a Democratic, you can't do that. Absolute power corrupts absolutely, another maxim. If you got a Republican governor, a Republican House, and a Republican Senate, to the victor belongs the spoils, and they can do what they want until you get to a court.
Now, another thing, he just mentioned something about fundraising. I just read an article yesterday about fundraising in this election tomorrow. And there were a lot of numbers I saw, but the spending by the Democrats is vastly more than the spending by the Republicans throughout the entire United States. Mm-hmm. Indeed, at least 20 days before the election, 73 Democrats running for local, for the congressional seats have raised over $2 million to 17 Republicans. So it's really a pretty wide swing to the Democrats. And the numbers, I think today in the Wall Street Journal there was something on this, or yesterday, about just a huge amount of money coming into Democrats. And I was just going.
That's a whole other forum.
Yeah, it is a whole another forum, and frankly, just kind of related to that, it's not necessarily money in that district coming in; it's money that's coming from other groups.
Yeah, I mean we're far afield of my expertise, Maureen's expertise, but I think the Democrats got caught sleeping in the 2016 election. I think they've awakened. I think they're roused, and they're out raising money, giving money, and actively seeking votes. Now, we'll see how they do tomorrow.
For those of you who want to learn more about dark money, our speaker at this lecture last week, Ellen Weintraub of the Federal Election Commission, spoke at length about dark money.
Yeah.
So, and there's a tape of that lecture that you can go look at. Please.
I'd like to listen to that too.
Alrighty. In the Supreme Court case, Arizona State Legislature v. Arizona Independent Redistricting Commission, Chief Justice Roberts had a really interesting aspect of his dissent. He basically...
What year was that?
2014.
Okay, go ahead.
He basically referred to the campaign to ratify the 17th Amendment of the Constitution a century ago by saying, what chumps, these people pushing for ratification. Didn't they realize that all they had to do was interpret the constitutional term, the legislature, to mean the people? the court today performs just such magic trick with the election clause, Article 1, Section 4. So I guess the question I'm asking you guys is, he seems to see that there could be an elastic danger to stretching the meaning of this so broadly. Do either of you believe that there could be such a danger constitutionally doing so?
Was that combined with that piece, a couple pieces out on the Supreme Court doesn't like mathematics? Was that part of this discussion in that case? I don't know one way or the other. I mean, is that particular section you're reading talking about the representative form of government or a model to test gerrymandering?
Yeah, I think in this particular section, he was talking about the commission itself and whether or not substituting the legislature with a elected commission was a valid enough stretch to redefine the term the legislature.
I don't remember the case.
I don't actually either.
I suspect from what you're saying is that citizens went, and I think this is a bone of legal contention. Citizens went with a proposition and put it on the ballot to replace the legislature, and the argument is you can't do that because the federal Constitution is supreme, and the federal Constitution gave this to the legislature. The federal Constitution is free. The legislature under the federal Constitution is free to delegate this to a commission, but the people are not necessarily free to substitute. And I think that is a viable argument. I'll just tell you off the top of my head what my gut would be. If the argument that you can bypass the people because that commission is a quasi-legislator or legislative body, I think that's not sound. I don't think that would carry the day before a court. I just think it goes too far.
Okay.
We have time for one more question, and then we have to give way to a wonderful course on the Beatles.
Hello. I was wondering, is there any argument that by having like districts that lean one way or the other, people in the minority whose votes like are very unlikely to determine the results and therefore reduce like any chance of them actually having someone who represents what they want? Do you think that inherently interferes with Article in Section 5 of Pennsylvania's state constitution in interfering with like their free exercise to the right to suffrage?
There is a concept in the federal case law and under the Voting Rights Act to give the minority, to allow or permit the drawing of a map to allow a minority group to have a voice. There is. Now, it's not really well formed at all in terms of what that means. I think that's what you're asking. So say it's the Hispanic vote.
Oh.
Is that what you're talking about?
Well, I'm more talking about like a political minority. Like if you look at like the map up here, I think like
a political, like another party kind of minority?
Well, yeah. Like on the map up here, like
not.
wherever Penn State is, I think that's in a very like heavily Republican district. So their votes are never going to actually matter. They're never going to have someone represent what they want.
At least they hope not, right?
Oh, yeah.
No, I think the answer to your question is no. In the United States, we have a winner-take-all system. And so you don't even have to be the gay party, the communist party to be disenfranchised. If you lose a fair and equal election, 50.1 to 49.9, then the other side wins. Hopefully, if the district, and I want to make this point, the district looks like that what does any elected official hope for most? Re-election. So hopefully in that kind of district, they're going to service all constituency. The real problem with extreme political gerrymandering is, assume that a Democrat has a district, and the Democrat has an 80-20 voter edge. She doesn't care about the Republicans. They can't vote her out. They can't do anything about her. She does care about taking care of her party all the time. And the only way to attack her is in a primary. And this happened to Eric Cantor of Virginia, who was an extraordinarily influential congressman. And I believe it was a biology teacher with no political experience, but a gun-toting, Bible-thumping, far right conservative, ran against him in the primary and beat him because he had dared to collaborate with the Democrats in Congress. And so what's the lesson that every Republican in Congress takes home, which is take care of your far right wing, because that's the only place where you can be defeated for re-election. Your left wing, which is what you're asking about, your voters who don't agree with your philosophy are substantially disenfranchised. And I think that's really harsh, but I think that's true. You'll note, and I know we're out of time, you'll note there is no Tea Party, there is no, what's it called, the Congressional Caucus? Freedom Caucus. There is no Freedom Caucus, there is no, in the United States Senate. Why? Because you don't have these fringes because there's no gerrymandering.
Thank you to our panel.
Thank you. And if I may, I want to thank our distinguished guests, but I also want to thank Professor Schlossman, who did everything from organizing this to getting us the tablecloth. Thank you so
Thank you.
much.
Yeah, and Maureen and I, we echo that. Steve, awesome job. Thank you for all your attention to detail as we run hither and there.
And
Thank
thank
you
you
to
to the
everybody for
audience
coming.
also
Thank
for
you.
being
Thank you, students.
so.
Thank you, Justice Baer, Dean Lally-Green. We're very honored to have you here.